Hearing in the appeal, Philomen Dean against Chanka Bhim.
First of all, may I say how grateful, I was going to say the board, but I am for the agreement of the parties to sit early. It's entirely for my convenience, but I'm very grateful to you. Secondly, I think this may be the first time that you have appeared before the board, Mr. Bahari Lal, since being called within the bar. Is that right?
That is correct, my lord.
Yeah, well, the board offers you their congratulations.
Thank you.
Now, with those pleasantries disposed of, let's move to a rather less congenial topic.
Yes.
And that is the delay that has attended the arrival of this appeal before the board. We have had prepared for us a chronology which makes for very unhappy reading indeed. And so far as one can tell, and of course we will listen to what both sides may have to say about this, there has been conspicuous delay on the part of both the appellant and the respondent. And it doesn't reflect well on the system of appeals to the board, not least because of the content of the particular item of litigation that we're embarked upon. So I give you notice that there may well be reference to this in the opinion of the board when it is delivered. So if there's something that you want to say about it, either side, now is the opportunity for you to do so.
My lord, I'm grateful for the opportunity. There was, in fact, an application which I don't know whether the board was aware of. The respondent applied to strike out this appeal for the very question of delay. And it was surprising to receive that because the appellant, once leave to appeal had been granted and the matter came before this board, there were attempts to have the appeal listed undefended because we were informed at that time that the respondent was not able to secure representation. However, we then received further correspondence from the respondent that they could and were trying to secure representation. And so, although we sought from the registry that the appeal be listed undefended, it wasn't listed. And then there was a delay where there was communication with the registry and communication with those representing the respondent, but not, I hasten to add, my learned friend or those instructing him now. They only came on board, it seems, last year. And when they came on board last year and indicated, as I say, they made an application to strike out, we informed them that in fact we were ready to list this appeal, and the only reason it hadn't been was because we were informed that the respondent was unrepresented, was arranging that representation with different people with whom the appellant corresponded, but then nothing further happened.
Well, quite, but I mean the chronology that we have been provided with makes it clear that the delay cannot simply be accounted for on the basis that the respondent was seeking representation. There was conspicuous delay during other periods.
Yes, my lord, I don't know whether you have the application to strike out and our response, because within the response I set out not simply a chronology, but also references to all of the correspondence with the registry and with the respondent to show that there hadn't been any delay. And as a result of that, the respondent did not proceed with the application to strike out because it was then clear that we had taken steps from when the appeal was lodged in 2011 to try and get it listed, but the frustration was the absence of representation by the respondent at that time, and then certain people who were willing to help but then abandoned, if you like, assisting the respondent.
Yes.
Until, as I say...
I don't want to delay this even longer, but you will find, and we provide you with a copy of the chronology, and if it's necessary, we'll give you permission to make written submissions on it, but you will find that there are other conspicuous periods of delay when nothing seems to have been happening at all, and especially in a case like this where the need for dispatch is self-evident.
I agree.
Anyway, let's proceed.
My Lord, I appear with, let me deal with the introductions, I appear with Miss Hyacinth Griffith from the Trinidad Bar and Mr. Joshua Hitchens, both of whom make their first appearance before the board.
You're very welcome.
I'm very grateful, my Lord. And my learned friend Rowan Pennington Benton appears for the respondent.
We hardly know Mr. Pennington Benton at all.
My Lord, we've provided a copy of an extract from Cross-on Evidence. It's the only matter of housekeeping that we need to address. It's page 43 of that extract which is relevant, and the first paragraph only. The reason we've provided that is that this is the current edition of Cross-on Evidence. The one we cited in the case is the earlier edition.
Right.
And so it's simply a point of reference. And it simply deals with adverse inferences. Adverse inferences may be drawn where a party fails to call a witness. I don't need to take your lordships through that in any detail. We adopt and pray and aid the case for the appellant, which enables me to address the board with brevity. In essence, my lord and my lady, we accept the approach of the board to concurrent findings of facts stated in the various cases on which the parties rely. We equally say that this case falls into that limited category where the findings are so unsatisfactory that it crosses into an error of law. And we say that because the reasons given by the Court of Appeal required the Court of Appeal to restate, in effect, the reasons given by the judge, to make sense of it and give certainty where the trial judge's reasons were not, we say, satisfactory. And even in this case, if we can show that there has been an error of law in those findings, then the board can still form its own view. My lord, we say that this was a straightforward case, simple issue before the judge, and so there should have been no difficulty in giving clear reasons in dealing with the respective issues.
Just before you go on,
sorry,
we can form our own view. Do you mean we can decide the facts, or if we think you're right, we have to remit it?
Well, in light of the observations of my Lord Care, I wonder about remission. But
well,
the application,
after all this time,
yes.
Are any of the witnesses still alive?
My understanding is that those who gave evidence in this case are still alive and could, and in any event we would be able to admit evidence of those who gave evidence but were not available in the normal way. The application, as my lord knows, in the Court of Appeal was that this matter be remitted for a retrial. That was the only application that was pursued, because we said that the reasons given were unsatisfactory. And it is not merely ground 1 or ground 2 we pray and aid, but it's the combined effect of all of the grounds that we say merited this matter being remitted for a retrial. I said I would be brief. As far as ground 1 is concerned, we've set out examples at paragraph 11 and 12 of our written case. And I know that the board would have considered that already. Essentially, we say that there is inconsistency where the basic evidence of the execution of the will was concerned and what was done with it immediately after. In short, if the will had been executed, these basic details should have been consistent. And the fact that they were not was a strong indication that the will had not been executed as described by the respondent and Mr. Budu, who were the only 2 witnesses to give evidence on the
Of course, there was a photocopy.
Yes.
And so you were inevitably alleging fraud and forgery, weren't you, Mr. Baharilal?
My lord, the way in which the pleading was, I think my lord is right, but the way in which the pleadings were settled for the amended defence is simply to dispute that it was the signature.
Well, I know, but bearing in mind there's a photocopy, or purported photocopy, I think you must be right to concede that I am right.
I do.
Very well.
Although I also concede that the amended defence was not framed in quite that way.
No, very well.
My lord, the essential point from Ramsaran and Houdan, and again we've extracted that, it's the reference E362 in the bundle of authorities. The hard copy may be slightly different. It's E355. And it's the citation from Lord Ackner and the reminder of the importance of carrying out a balancing operation between the credibility of a witness and other matters, which we say was not followed. This is because adverse inferences were drawn against the appellant that the deceased did not trust her and that they were not as close as she testified that they were. And whilst it's right that inferences can be drawn from facts, whether favourable or adverse to a party, we accept that, what the court should do is to look at all of the circumstances to see if they give rise to that inference on the matter in question. And can I invite you briefly to look, please, at E377, the hard copy bundle of authorities E370.
Sorry, you'd have to help me with this, Mr. Bowman.
Yes,
Which authority are we looking at?
this is the authority of Richard Evans.
Yes.
And it's E377, should be on the electronic PDF.
Yeah.
But the hard copy seems to have it at page 370 and just the bottom here.
But this is page 677 of the report.
Yes, 687, that's correct.
677.
687.
687
687, thank you very much.
of the report.
Oh, yes, I'm so sorry. Yeah, thank you.
And it's the middle of the second paragraph, just below the middle of the page. The court must look at all circumstances to see if they give rise to a reasonable and definite inference on the matter in question. If they give rise to conflicting inferences of equal degrees of probability so that the choice between them is a matter of conjecture, then the applicant has failed to prove the case. And it's that approach that we say should have been followed in this case, but was not followed in this case. We say that there was a failure to balance on the state of the evidence that the appellant was in no different position to her siblings. So where, in this case, the judge held against the appellant, well, you didn't have keys to the deceased bedroom, that was neutral at best, but certainly not a point that could be cast against her credibility. And just to give my lords the reference, this is paragraph 17 of our case.
This is all a matter of impression and deduction on the part of the judge. I mean, this is the stuff of judgment. I mean, the absence of a key to his bedroom, which seemed to be a particular issue with this testator, may, in the mind of one person, be of great significance, and in the mind of another, of no consequence whatever. But if the judge plumps for one of those, is he to be challenged on his decision? I mean, that's, as I say, the stuff of judgment, the exercise of judgment as to the significance of particular facts.
My lord, I accept that it is a matter for the trial judge to determine what weight to attach to that. But where he is confronted with evidence that neither siblings nor the appellant had access to the key, it couldn't then be a point against the appellant only. At best, this is why we say it was neutral. It couldn't be a factor from which to draw an adverse inference against the appellant. And having done that, he seems to have considered that of tremendous significance, it seems, in not believing the appellant's evidence in this case. And coupled with that, the complete failure of both courts below to consider the implications of the failure to call a witness who is said to have witnessed the will and who was the main beneficiary under it, we say is inexplicable. This is the record at page 168. Where the Court of Appeal at paragraph 26, rightly we say observed, this is page 168, paragraph 26, top of the paragraph, there's very little by way of explanation for the absence of Charles Cardanas and Valère, two persons who saw the executor locate the will on that night, and on the issue of rebuttal of the presumption of revocation. Your Lordships have it.
Yes.
Essentially, the short point is this. Here is a person who is both a beneficiary and a witness to this will being produced. He doesn't come to give evidence. He doesn't seem at all interested in supporting the trial. And so in those circumstances, where you are looking at adverse inferences, which the judge plainly had in mind, exercising his judgment on the evidence, this was a point heavily in favour of the appellant, and the judge erred in not holding it in her favour.
There are all manner of reasons that someone has not given evidence. I mean, I do appreciate that there is a line of authority to the effect that an inference can be drawn by the absence of testimony from a plainly relevant witness. But that inference doesn't have to be drawn inevitably. people may be reluctant to come and give evidence in a contentious matter such as this. It doesn't necessarily and inevitably follow that the absence of that witness casts stud on the veracity of the case that has been made on the part of well, I suppose the plaintiff in this case.
Well, my lord, I agree, subject to if there's an explanation for why that witness is absent. Maybe the witness was unwell or some other such thing. As long as there's an explanation for why they're not there, then it's perfectly possible to say, well, look, that point is therefore neutral. But where, on the face of it, this was a witness, beneficiary and witness to the will, who had, in separate proceedings, issued an affidavit, who is then not called, then in those circumstances we say that that calls for an explanation, and absent any explanation for his absence, it's an adverse inference fairly drawn against the
Well, it's usually better to concentrate on the evidence that is given.
Of course.
Rather than speculate about why evidence hasn't been given. And
again,
on the evidence that was given, of course, you've got Mr. Bhim, the executor, and Mr. Boodoo.
And Mr. Boodoo.
Yeah.
Who are the only witnesses.
Very well.
As I say, subject to that, there is this gap which we say should have generated an adverse inference. But where the respondent had the burden of proving the existence of the will, calling Charles Cardenas as a witness, if he could be called and could not be shaken in cross-examination, would have been powerful evidence in favour of the respondent. And again, we accept that. But although the law is well-trodden territory, and I've taken, my lord, to the extract from Cross, similarly, if that witness is not called, who could give powerful evidence in favour of the respondent, that gap goes the other way. And that's the short point. Similar position in relation to the witness Émile Valère, who also apparently witnesses the will, but is inexplicably absent. And it is no answer, we say, as the respondent contends, that there is no property in a witness and could have been called by the appellant, since these were witnesses on the respondent's evidence who would have supported the respondent's case. My lord, those
Did your client consider calling the witnesses? Did your client consider calling the witnesses?
Not after receiving the statements of the respondent and Mr. Boodoo, who were indicating, well, these were witnesses who could have supported his case. The expectation in the adversarial system would be, well, you're going to call all witnesses who support your case.
Yeah, well, I suppose you could have interviewed them at least to see if
I can't say that that took place, but we certainly understood that they would be called if they would support their case. Sorry.
Was the case management for a contested probate trial in Trinidad at this time such that the parties generally didn't know which witnesses the other side were going to call until the trial was at the calling the witnesses stage?
My lord, it may well be that the management of this wasn't dealt with in the way in which it would be dealt with under the civil procedure rules, simply because I think this was an old rules case. So the case management conferences and so on, which would deal with all of these matters and scheduling, didn't happen in the same way. There was a period of transition and conversion, but as you would have seen from the way in which the notes of evidence are framed, it doesn't seem that the judge who was assigned this case had any prior dealings with it.
No, it may not have been docketed, but you really are asking us to assume, I think in the submission you've just made, that your side simply didn't know who they were going to call.
Well,
until they weren't called.
Well, they were disclosed, as we understand it, from the affidavit evidence. That would have been the standard thing, file and serve. We accept that was done. But these were the only witnesses who were going to support their case, although it would have been open to the respondent to file further evidence right up until trial and then seek permission to rely on it. My lord, that's ground one. Ground two, I can take that even shorter. We say that that's a simple matter of the respondent bearing the burden of proof, and as the plaintiff at trial, the respondent introduced the contradictory affidavit as to when, if he returned the will to the deceased. For your lordship's reference, or the board's reference, forgive me, this is the record at page 23. And it's line 20.
Is this the 2 days, same day discrepancy?
No, this is the introduction of an affidavit which had been filed to apply for probate of the will.
I know, but when you say this, the burden of proof was on the plaintiff and therefore he should have cleared up this discrepancy, I was wanting to be reminded what the discrepancy was.
The discrepancy, my lord, in fact, it's at page 161, which is dealt with in a good summary at paragraph 11 of the Court of Appeal's judgment. This is page 161 of the record. And there were conflicting...
I think I'm right. It's the 2-day, same day
Yes.
issue. That's what I said
Yes,
to you.
yes, sorry.
Forgive me. Yes. You're
That is
really
essentially-
saying that where the burden of proof is on the plaintiff, it's for the plaintiff to look through the evidence given on behalf of the plaintiff and say, here is a discrepancy. We must deal with that. Is that honestly your submission, Mr. Harry Lau?
My lord, we say that having introduced the discrepancy, if they wished to explain it, they could have done so. And we're simply saying that in terms of cross-examination, if it was an inconsistency left on the evidence, then the appellant, then the defendant, would have been entitled to rely on it and say, well, look, this is a discrepancy which has not been explained.
Very well. Ground 3.
And that's the short point in relation to it. My lord, one other matter, just before I move to ground 3. There was uncertainty in the trial judge's approach as to whether the will existed or the presumption of revocation applied, and that confusion may have affected where the burden lay and how it was dealt with. And that brings me to ground 3, to which I turn now. In the trial judge's final analysis, this is page 90 of the record. And it's the second paragraph, bottom of the second paragraph, last line. I therefore accept the evidence given by the plaintiff and Mr. Boodoo and hold that the presumption of revocation of the will by the deceased has therefore been rebutted. So it appears he settled in the approach that the presumption applied. And if that was so, then the burden of proof lay firmly on the respondent, as did any duty to explain any inconsistency in relation to the execution of the will. As to the trial judge's judgment, the Court of Appeal took the firm view that he was not clear in his reasons and why. And this is page 164 of the record, paragraphs 17 and 18. And it's dealt with in the parties' cases, but in essence, we don't disagree with the Court of Appeal in this regard. And we say further that that was why the Court of Appeal was required, in light of this lack of clarity, to remit the matter for a retrial. We have also given another example in our case. This is at paragraphs 30 and 32. For the E reference, it's E226. And this is a situation where the trial judge simply got it wrong in his analysis, where he drew adverse inferences against the appellant on the presumption of revocation by relying on the evidence of Mr. Bruce as supporting a close relationship between the deceased and his daughter Maria. And for that, I can give the board the reference. It's page 89 of the record, bottom of the page. Now, the role of Maria in the case was considered by the Court of Appeal, stating, Maria, who is the only child mentioned in the will, who lived opposite the testator, was curiously absent from the entire proceedings. And this is paragraph 26, record page 168. Now, the absence of evidence for Maria did not merit any finding as to the closeness with the deceased and Maria. Or more significantly, there was certainly no basis to find a lack of closeness with that of the appellant. If there was any inference to be drawn, it was one adverse to the respondent for the reasons we've given in relation to not calling a witness who could have been called but was not called, and who again, on the evidence, expressed no interest in either proving the will under which she was to make a substantial gain. Maria, the board will remember, was to inherit the house of the deceased under the will. The trial judge held as a specific point against the appellant that she would make a substantial loss from the proceedings if she lost, that is, the loss of the barn. And this is in the record at page 90 judgment of the judge says that the defendant, appellant, will suffer a substantial loss, namely loss of the income from the business at 6 Fourier Street, Marabella. We say this was plainly wrong. The appellant, and this is not something that was dealt with by either of the courts below, made no claim for the bar or anything else. She made no claim to any specific property. And if, my lords, the board...
But she would have made a significant loss. It may not have been at the bar, but she definitely would have been worse off if the will was proved.
Well, she would have been worse off if the will was proved generally, and this is why I wanted to take the board to page 14 of the record, because the way in which she framed her claim at paragraph 1 of the amended defence was accepting that she was only one of the persons beneficially entitled in the estate.
Yeah, but even if she was only one, she was certainly going to benefit to some extent.
She would certainly benefit than if she was written out.
That's why we're all here.
Yes, I accept that, my lord. I accept that. But in terms of saying, well, look, you would have had the interest of the bar, you're holding that against her, she wouldn't have got that. That's the short part. And that was consistent with the evidence called from Mr. Bruce, who was clear in what the deceased told him, that what he...
Well, it's all a matter of degree, isn't it, really? I mean, the judge may have got it wrong in deciding that she would have lost the bar, or she would have been able to keep the bar if it was a situation of intestacy. But, I mean, she certainly was going to lose if the will was proved.
But I accept, my lord, if it assists that had the will been proved, she gets nothing. But had the will not been proved, she certainly wouldn't have gained significantly. Everything would have been split up between the siblings. And that's essentially the short point where we say the judge got it wrong.
Just as a matter of interest, what has happened to this estate in the many years that have passed since the unfortunate
My understanding is
decease?
no change from the status quo at the time the appeal was lodged.
Oh dear.
So she's still running the bar.
Can I take instructions?
Yes.
Mrs. Griffiths was the attorney at the time. Well, my understanding is that the answer is yes, she's still running the bar.
So the delay really has benefited her.
My lord, insofar as she was running the bar and gaining an income, that must be right.
Yes, very well.
Mm-hmm. Right, where are we now, Mr.
My lord,
Mahela?
I'm coming to the end of this point. We've drawn attention to Section 24.2 of the Administration of Estates Act. It's the same point in relation to how the estate would be distributed on intestacy. And whilst the respondent makes the point in their case that the alternative interpretations that we have offered in this appeal, they've said it's far from clear that these submissions were made to the trial judge, and I deal with that head on. If your lordships, if the board turns to the record at page 39, again, I accept a trial judge doesn't need to note down everything, but at line 16, beginning with addresses, the note could not be shorter, and so it should not be assumed that the appellant did not make significant submissions in this case. We simply don't have a record of the whole of the submissions in the notes of evidence. And when one looks at how the submissions were framed for the Court of Appeal, I think the board can be confident that pretty robust submissions were made at the trial stage, it being the usual first and last opportunity to make the best case possible. My lord, final ground, ground 4. This relates to the expert evidence. Forgive me. Although I'm moving on to ground, are there any matters your lordships would wish me to deal with before I deal with the final ground?
Thank you.
Ground 4. As to ground 4, this relates to the expert evidence in two respects. Firstly, the procedure adopted by the Court of Appeal, and secondly, the ruling that followed that application in relation to the expert evidence. Of course, we accept that then leading counsel Stanley Marcus, Senior Counsel, invited the Court of Appeal to proceed without hearing from the attorneys, but for the reasons set out in our case, we say that this was the wrong procedure where the court did not call for a transcript. The first step before the appeal was listed should have been for the transcript to be obtained, and then we would have had the recorded evidence as what exactly took place at the time of trial.
Have we got one now?
We don't. And
Very well.
It may be that at the time this case was listed, the recording system was not in place. I do not know.
But had the appellant called for the transcript?
Sorry?
Had the appellant called for the
We
transcript?
tried to obtain it. I'm grateful to Mrs. Griffiths, who was there. There was no recording system at that time.
So there was no
So
transcript?
there was no transcript.
Oh.
This is what
So the point that they should have called for the transcript doesn't
this is what
doesn't butter any parsnips.
No, sorry. What she says is the only document we have is what the judge noted.
Yes, judge's
We
notes.
tried to obtain a transcript, my understanding, but we were not able to get one.
But if the thing wasn't recorded, as I
No,
understand,
that's where I think there's the confusion. I think that there may have been a recording system, but we couldn't obtain it because we. Well, again, I'm guided by Mrs. Griffiths. There was a panel typist, I'm told.
Some of us are old enough to remember the days of stenographers.
Stenographer, yes.
Wow.
but I mean, the point.
Either or.
But as I understand it, you are accepting that, in fact, even if everybody shouted for the transcript from the mountaintops, there wasn't one. Nothing has ever emerged.
And it does, well, at the time we've tried to obtain it. I can only speak from when I was involved.
Yeah.
We couldn't obtain one
No.
at this stage, but attempts were made, and perhaps if they were made earlier at the time, it would have been possible to obtain it. But, my Lord, the fact of the matter is there wasn't one, and Mr. Marcus indicated he wanted the court to proceed on the papers that were available. So even if the Court of Appeal was right to proceed on the papers, and of course that was the position invited, what that would have done was rendered the attorney's untested evidence fairly neutral. But there were important factors that favoured the conclusion that the appellant had made the application to adduce the expert evidence. And I simply commend my lords at the board to that now. Firstly, it would make no sense, and therefore it was hugely improbable, that a party who would go to the trouble of asking for this report, dated 2001, to then not apply to adduce it. This went to what her pleaded defence was. And that should have weighed heavily with the Court of Appeal, where there were gaps in the trial judge's notes. Secondly, the chronology of the documentation was telling. We've posed 3 questions in our case. This is 230 of paragraph 48. And we say that this is what the Court of Appeal, at the very least, ought to have done in examining whether, in fact, this application was likely to have been made. In addition, there should have been a comparison with the dates that the pleadings were filed. And if the board looks at page 8 of the record, again, we say it's quite telling. You can make out in the top right and the top left pages 8 and 9 respectively the date of filing, and you'll see there the 20th of June 2001. Paragraph 2 of that defence disputed the will was signed by the deceased and executed by him, and that was repeated in the amended defence at page 15 of the record. If you then turn to page 106 of the record, you can see there at the bottom of the page when the expert received the exhibits from then my instructing attorney, 27th of June 2001. And bearing in mind the report is then dated, and you can see it in the middle of the page, 29th of October 2001, that was consistent with the preparation of that report to support the pleaded defence only 4 months earlier, where the expert notes, as I say, he obtained the exhibits on the 27th of June 2001. 7 days after the defence is filed. In terms of the respondent's position, if you turn to page 12 of the record...
Are we leaving Mr. Pamasar's report?
Sorry?
Are we leaving Mr. Pamasar's report?
Yes.
Because, I mean, obviously, we look at 108, we look at the conclusion, and
Yes.
we ask you, would it, if it had been admitted, could it have carried any weight?
I am going to deal with that.
Very well.
But if I may, a little later.
Yes, of course.
Later. Page 12, the respondent's original reply, this is 25th of June 2002, in response to the defence expressly maintained the execution of the will. So, in short, both parties knew that the signature was disputed as an issue for trial. So against those dates and the content of the pleadings and the expert report, which I'll come to briefly in a moment, it's completely improbable, we say, that an application to deduce the expert report was not made by the appellant because it was central to her pleaded case. And those dates, coupled with the inconsistencies in the notes of evidence, which we've highlighted at paragraphs 50 to 54 of our case, yes, 50 to 54 of our case show that the application must have and was made. In terms of the notes of evidence, it is worth looking at page 20 of the record, which is the very beginning of the notes of evidence in this case. Because as the board is aware, it's said that this application was made at the very beginning, first day of trial.
Which page do you want us to look at?
Page 20 of the record.
Yeah.
And this is the first page of the notes of evidence. And we say that there's uncertainty, again, with the notes, because there are a series of entries, issues, files 16th of February, 16th of April, submissions 12th of April 2007, none of which, having looked at the chronology we've prepared in this case, seems to relate to anything that has actually been filed. Query, what submissions is the judge referring to? And if you...
So when did you get... Of course, your amended defence, which we've got at 14, came
Yes.
very, very late. I think it took you about 6 years to take the anime revocandi point. When did you get permission to make the amendment? Was it at the outset of this trial, or was it earlier?
Looking at the entry on page 20, it simply marks leave to amend.
Well, quite.
But amend what? I can't say.
Could it be the amended defence that had been served 2 months earlier?
It's possible.
Yeah,
but
very well.
I'm afraid I can't take it.
If so, that explains that bit of his notes.
If it is, then
Yes.
it could explain that.
Very well.
But the absence of detail in the notes as to what's being discussed at that time makes it difficult to say that it would have necessarily related to that. But when we look at the chronology, which we've agreed, if you look at page 210 of the chronology,
This is E210.
this is page number 210
Yeah.
in the numbering. It doesn't seem to relate to any of the dates in the chronology at the bottom of the page going over to the next page. So I don't think it's safe to assume, in response to my Lord Wilson,
Very well.
as to what it relates to.
Okay,
But
thank
in
you.
all of these circumstances, the notes of evidence couldn't be treated as decisive, and that's the short point. And dealing with my Lord Wilson's question, as to the weight that could be attached to the expert evidence, had it been admitted, it should be noted that the expert Glenn Pamasar is one of the foremost handwriting experts in Trinidad and Tobago. And if you look at page 146 of the record, express reference was made, page 146 of the record, it's the top two paragraphs which cite extracts from the cases of Samuel and Sulet and Ahau, which illustrates that his opinion is highly regarded by the courts in Trinidad and Tobago. So where he framed his opinion in this way, he says, from the available material, it has been concluded that it is probable that the questioned signature on Exhibit Q1 may not have been executed by the specimen writer, that's the will and the deceased. That expert opinion, we say, would have carried considerable weight in support of the appellant's case. And stepping back from it, of course...
My lady has a question.
Sorry.
A sort of halo effect.
Sorry?
A sort of halo effect from the fact he'd appeared in other cases,
Well,
rather than by reference to what he wrote in this.
well, I'm not a halo effect necessarily, my lady, but yes, in part, the regard in which he was held and the importance of his opinion, but then dealing with what he actually said. When he expressed his opinion against the background of what we know of this particular expert, that there was, that it was probable that it was not the deceased's signature. When the judge then steps back and looks at all of the evidence as a whole, which inevitably he would have to do, this is one small part of the evidence, the expert's opinion would have put a different complexion on what we say were the inconsistencies and complaints.
Did you say that he said that it was probable that it was not?
Probable that it was not his signature.
Well, can we just read that more carefully, Mr. Baharilal? Probable that it may not have been.
May not, forgive me.
Yeah.
By no means conclusive.
May not.
So, his distinction has led him to be appropriately cautious.
Yes, and as one would expect from Mr. Pamisar.
Yes.
Of course, I accept that he says that he uses the word inconclusive a little later in that report. So it's may not and it's inconclusive, but on balance it would have favoured the appellant. And we say that the combined effect in then standing back and looking at all of the evidence puts into context, and a different context, the inconsistencies and complaints in relation to the respondent's evidence at trial. And finally this, my lord, the Court of Appeal agreed, this is the record at page 166, paragraph 21, top of the page, that if, it's page 166, paragraph 21, Court of Appeal's judgment, that if the application was made to adduce expert evidence, then that would merit a retrial, which we say was the proper order the Court of Appeal ought to have made, and is the order that we seek from the board. Lords, my lady, those are my submissions, building on the written case and those matters I've taken you to. Are there any other matters the board would wish me to deal with?
I think not. Thank you very much indeed.
I have one moment to just address my junior friend.
Yes.
I'm very grateful. Thank you.
Ms. Griffith, do you follow? No. Yeah. Well, we'll adjourn for a few minutes to see where we are and sit again in about 5 minutes' time. Well, the board is very grateful to Mr. Baharilal for his succinct and customarily felicitous presentation, but we don't find it necessary, reluctantly, because we always enjoy hearing from Mr. Pennington Benton. We don't find it necessary to call upon him. Now, I have to revert to the topic that I mentioned at the outset, and that is the question of delay in this case. The circumstance that the appellant is still running the bar many years after the death of the deceased is something which is obviously concerning to us. So what the board will do is to allow both parties, because, as I've said already, without making a final judgment on it, there appears from the chronology that has been prepared for us to have been fault on both sides, to allow both parties to make a written submission to explain the delay in taking this appeal to the board. It doesn't mean that there will inevitably be any adverse comment, but we want to be sure that if there is such criticism, that the parties have had an opportunity of putting their case on this particular issue before us. Right. Court.
My Lord, may we have a copy of the chronology?
Yes, you do. You certainly may. I'll make sure that both of you have that. Okay.
How many days are we going to give them for filing that?
1 week.
It'll be done within that time.
I'm sure well within that time. Right, good. Court is now adjourned.